Hello, everybody. Welcome to this webinar. Today, we're going to discuss, or the heading of this webinar is From Death to Executor, What to Do Next. We'll explain that just now. Let me just introduce myself, etc. Before I do that, please note the house rules. Please submit any questions via the chat box. These will be addressed during the session. A dedicated team is on hand to assist with your questions. Kindly keep your microphones muted and your camera turned off throughout the session. Thank you. All right, let me introduce myself quickly. Problem here. All right, I'm Jan Jordan. I'm the estates, deceased estates department here at Young Al Jordan Attorneys. You can see my telephone number, my email address, and our website address. You're all welcome to contact me if you need any assistance. Um, who are we? Young Al Jordan Attorneys I've been practicing for my own accounts from the 1st of March 1993. So that's just over 33 years. At Jan Elliot Group of Companies, we don't sell property transfers or bonds or wills or deceased estates or administration. We sell certainty at the moments people are most exposed, and that is who we are. We Honesty, integrity, and transparency are the principles that guide everything we do, and I challenge anybody and everybody to challenge us and keep us accountable to this statement. All right, a little bit of advertising. We specialize in the administration of deceased estates, property transfers. We draft wills, we do transfers of properties, registration of and the cancellation of bonds. We are on the panel of ABSA and FNB, Nedbank, and Standard Bank panels, and we also do estate planning, which is very important. And you will realize now, going through this session, how important estate planning is. Yeah, from death to executor, what to do next. Just as an introduction, I'm going to talk a little bit about planning. Then I'm going to share with you the 10 steps that I think it's necessary from the time that somebody passes on. And then we're going to discuss frequent questions that we get from clients. So when a loved one passes away, families are often left with left asking, what do we do now? The period between death and the appointment of an executor can feel overwhelming, confusing, and emotionally draining. This webinar will provide clarity and practical guidance for those crucial first steps. Now, before we carry on, I think it's very important and appropriate that I explain the difference between a nominated executor and an appointed executor. For those of you who don't know what an executor is, that is the person that the Master of the High Court will appoint in place of the deceased person to wind up his estate. Now, a nominated executor is the person that's nominated in the will. That nominated executor has got zero authority to act on behalf of the deceased until he's appointed by the Master of the High Court. That's where the complications come in. That's the purpose of this webinar. That gray area from death until the executor is appointed. Important, the person's death does not immediately give the heirs the right to deal with the estate. Yeah, people, we get it often. Somebody passes on, the children jump in, and they just want to take over and sell and sign lease agreements and sell the property and sign for it. All of that's irrelevant, and it doesn't mean anything because they do not have the authority. Okay, so only the appointed executor has got that authority. The estate enters a legal process, and only once the master appoints an executor can somebody legally step into the shoes of the deceased and begin administering the estate. I will refer to it a few times, that sometimes you have to be practical. Okay. We'll get to all of that. Um, yeah, let's leave it there. When I get to those points, I'll discuss it. Now, the first week after death is not the time to make major decisions or distribute assets. It's a time to protect the estate, gather information, obtain professional advice, and allow the legal process to begin. Now, a little bit about planning. A very profound statement that I read the other day. It says that planning is bringing the future into the present so that you can do something about it now. So profound. So, estate planning is an act of kindness. Hear me out. An estate planning is an act of kindness, and I'll explain to you why. We often think of a will as a legal document. I see it differently. A will, together with proper estate planning, is one of the kindest things you can leave your family with. It doesn't prevent grief, but it prevents unnecessary confusion, conflict, delays, and expense. So that's what we're going to discuss today. If you do your estate planning properly, and you have a live file, which we're going to discuss now. It will make all these difficult questions and when it feels overwhelming, so much easier if you've got a plan in place. So we refer to the following as a life file checklist. I'm going to read to you the top paragraph. Just on the left hand, you see I say that if you want a copy of this live file, then you request it from Chardre, and that's the address of Chardre, wills@youngjordan.co.za. Now, if I read with me that top paragraph, life is unpredictable, and having all your important documents organized in one place can make a world of difference for your loved ones in the event of your passing. Your life file ensures that your family knows where to find essential documents such as your will, identity documents, banking details, insurance policies, and other key information. This not only reduces stress during a difficult time, but also helps to prevent delays in the administration of your estate. By keeping your life file up to date and accessible to a trusted person, you provide your family with clarity and peace of mind when they need it most. And it's mostly needed in this period that we're going to discuss today, and that's from death until the executor has been appointed. So this life file checklist, very important. Do yourself a favor, email Chardre and request from her to send you a life file checklist. Now, the next 10 steps is what I think is the most important steps from death until the executor is appointed, and I'll explain to you why. The very first thing that you must make sure to obtain is the official death certificate, because the death certificate is an essential document required for the administration of deceased estate. We have to have a death certificate, otherwise we can't proceed with the winding up the estate. The death certificate can be obtained from the Home Affairs, Department of Home Affairs. The funeral parlor, in most cases, will assist the family in obtaining the death certificate. And then I've highlighted a very, very important point. Make sure the death certificate reflects the marital status of the deceased correctly. We often get it where the surviving spouse pass on, and then the death certificate still indicates that she's married, or she was married at the time she was alive. And we all know that her late husband passed on, and then it creates a lot of confusion and a lot of delays. So when you ask the person or the funeral parlor who's going to assist you with obtaining the death certificate, please ask them to make sure that it reflects the correct marital status. I believe it can take up to 8 months to change that death certificate, and you can't afford that in terms of winding up the estate. The second point that you need to do is to find the original signed will. Now, I highlighted and I've typed it in bold that you have to have the original will. The master of the High Court will not accept a copy or even a certified copy, we have to hand in the original will with the master. For those of you who've got a will with the big corporate companies and they keep the original, do yourself a favor and find out if that will still exist. Without an original will, don't have a will, and for all practical reasons, you have died intestate, and the Interstate Succession Act will then kick in. So I just remind you to check the life file, and then that's one of the lists on that list, one of the documents that you have to have, the original signed will. Then point 3 is to arrange the funeral and keep your documents, because these documents may become claims against the estate. Okay. Arrange the funeral is very easy. If you phone the funeral parlor, they will guide you in everything that needs to be done. The fourth thing is, especially if there's a house or a fixed property, is to make sure that it's safe. It's locked and secure. I mean, if there's people staying in the house, let's say the surviving spouse or the family, etc., then it's a different thing. But if it's one person and that person is passed on, make sure that the house is locked and secured, and record any valuables that's removed. Safeguard documents and keys, and check the insurance of the property. We'll get to that now, but insurance, very important. Step number 5, as soon as possible after loved one has passed on, the family should contact the person named as the executor. This ensures that the estate administration process begins without unnecessary delay. Let me explain here quickly. If the deceased has nominated an individual and not an attorney, an auditor, or a trust company, then what happens in practice, if Joe Soap has been nominated as the executor, let's say he's a family member, then Joe Soap is welcome to come to us, and he will then give us a power of attorney. He will stay the executor, but we will do all the work. So to all the nominated executors out there, you need to make contact with us when the deceased who nominated you pass on. 6, list the assets and important information. Now, compile a preliminary list of bank accounts, etc. I'm going to go to the next slide before I go to number 7. This is what we refer to, or this is the list that we use, that we send to clients when somebody's passed on. We ask them to send us the documents or gather all these documents so that we can report it to the master of the High Court. So this is the documents that you as the beneficiaries should get together, and then when you come to us, bring all those documents with. Again, if you want a list of the documents that we're going to need to report an estate, please email Shardre and she will email it to you. So those documents are very important. 7, do not start dividing the estate. Now, we'll discuss it later on. It's sometimes not practical not to divide it, but we'll get to that. But the standard advice is do not start dividing the estate. And I'll tell you why it's important. Even if it's in the will, that says little Johnny must get the couch, whatever. There are 2 things that might be applicable. First, the estate might be insolvent. When the estate's insolvent, it means that there are more debt than assets. And then the Insolvent Act kicks in. In short and in simple terms, all the assets will be sold and divided amongst all the creditors, and your heirs won't receive anything if it's insolvent. So that's the one point. If you start handing out furniture, etc., that the estate might be insolvent, and that's just creating a lot of complications. And then the other thing is, you have a will, an original will, but who's to say that there might be another will? The deceased might have drafted another will that he signed, and you have to go according to that. So in the will that you might have, that might say little Johnny must get the furniture, the household, but in the second will, the latest will, might indicate that somebody else must get it. So be very, very careful on that point. Right, we've discussed the documents that will be needed to report an estate. It's very much similar to the life file checklist. All right. Step 8, protect the financial position. So people, um, have a look at the financial commitments of the deceased. Is there a bond that needs to be paid? Is there municipal accounts, levies, insurance premises, motor vehicle installments? Please do not cancel debit orders without advice. Assets could become uninsured or contracts fall into arrears. My advice is if you get to a point like that, contact us as soon as possible so that we can guide you through this process and help you make informed decisions during this difficult time. We will discuss later on if it's necessary to inform the bank when somebody's passed on. And it's very much to do with this whole thing of protecting your financial position, and that if you close the bank account or inform the bank and the account gets stopped, if they stop the account, that might mean that debit orders can't go through. So be very careful on that point. Then point 9, notify relevant parties, inform relevant institutions such as the deceased employer, financial advisor, insurance companies, pension and retirement funds, and the banks where necessary. You'll see that I made a question mark next to banks. Our advice is not to inform the bank because they will put a hold on the bank, on the account. Our advice is that leave it up to us as the executors. We will, once we've been appointed as the executor, we will then deal with the bank and we will ask the bank to close the account. Because once the bank there's a hold on the account, then debit orders, etc., can't go through. So be very careful when you make a decision on that point. Then number 10, obviously very important, is to report the estate to the Master of the High Court. Do not delay. The sooner the estate is reported, the sooner the Master can issue the letter of executorship, the sooner the legal process can start. People always ask us, how long does it take to get the letter of executorship? How long is a piece of string? With the Master, we normally say it can take anything between 3 weeks and 3 months. Yeah, I don't know what to explain there because the Master is supposed to do it within a day or two, etc., but it doesn't happen in practice like that. So it's important to know how long it takes for the Master to issue the letter of executorship, because there might be decisions that need to be made during this time while we're waiting for the letter of executorship. So those are the 10 points that I think that you should think of and do straight after death until the executor has been appointed. Now, we're going to look at frequent questions and answers that we get from clients. But before I begin, let me explain the difference between a liquidation and a distribution account, or an L&D as we refer to it, and a cash statement. Now, L&D account, when you wind up an estate, at one stage, the executor has to prepare and draw up an L&D account. The L&D account will have all the assets, all the liabilities, all the expenses, estate duty, everything will be in that L&D account. It's basically a summary of everything that's in the estate. Okay. Now, here's the crux of an L&D account. The L&D account will only reflects what is in the estate at the date of death. You need to understand that. And I'll explain it to you now, why it's so important. Let's say you're a salary earner and you receive your salary on the 25th of a month, but you pass on the 24th of the month. And the next day, the day after your death, your employer pays your salary. In the L&D, we will reflect whatever was in your account on the 24th, the day before your salary was paid. In the cash statement, after we've now finalized the L&D account, the master has approved it, and we are now ready to distribute whatever we've got in the account, we will drop a cash statement. So that salary that we received after death will be shown in the cash statement. Or if that's where it will come in, and we will show you that we've received X amount after death, and that's how, and then show you how the distribution is done. Yeah, so it could be the other way around as well. So on date of death, there was X amount in your bank account, but 2, 3 days later, a debit order goes off, or uh, whatever the case might be. We again have to reflect in the L&D account what was in the estate, or what was in the estate on date of death. In our cash statement, we will then reflect that debit order went off, whatever the case might be. So if you understand that principle of an L&D account, it reflects the values as per date of death versus a cash statement, which reflects all the money that we have or we don't have. If you understand that, then the following questions might make a lot more sense to you. So question 1, can we access funds from the deceased bank account to pay for the upcoming funeral? Now, if you go to the bank and say, Mr. X has passed on, please can I withdraw the money? The bank will say to you, no, you can't. The correct answer also is that you cannot access funds from the deceased bank account to pay for the funeral. However, here's where a bit of a gray area comes in. You need to be practical as well. So what happens often is one of the children of the deceased have got access to the bank accounts via internet, and they will physically go into the account and then pay for the funeral, withdraw money, or whatever the case might be. If that happens, it's not 100% correct according to the law, according to the rules, but if that happens, it's not the end of the world. And yeah, obviously, if the estate is insolvent, that's a major problem. But all those monies that's withdrawn will then reflect in the cash statement. So if I'm the heir and there are 3 heirs, I've got access to the account, and I go in after death and I withdraw 40,000 Rand for myself, and I go and spend it. And we find it often that the other heirs are then very upset. Fair enough, a good reason to be upset, but we will then correct all of that in the cash statement if one of the heirs have taken money, for instance, out of the account. Okay, so if you inform the bank that the person has passed on, the account will be frozen, and and only when the executor has been appointed can we really actually do something about it. The executor can only close the account once the letter of executorship is issued. So if you go to the bank without the letter of executorship, they're not even going to listen to you. Okay. The bank will not authorize access to funds for any party, including the spouse. They won't do it. So just as a side note, the bottom, I said yeah, it's important to make provision for the cost of your funeral. And that's all part of estate planning. So I'm inviting people that come and see me, let's look at your estate and plan all these things. This can be done by taking out a funeral policy or by making advance arrangements with funeral parlors. Many funeral parlors allow you to pay for your funeral during your lifetime and will provide a written confirmation that the funeral has been paid for. This can ease the immediate financial burden on your family and provide valuable peace of mind during an already difficult time. So again, the question we also get, can money be withdrawn from the deceased bank account? The correct answer is no. But if it happens, we will deal with it. Okay. So I can't tell you that you can do it. It's not the right answer that you can draw money, but sometimes one need to be practical. and I'll explain it later on when it comes to lease agreements and so forth, when I say that you need to be practical about a few things. All right. What happens to assets? Can they be sold? We're going to look at immovable property, vehicles, firearms, and movables. Each asset class is examined in the slides that follow. Let's start off with immovable property. That's a house or a building or so forth. Remember, like a vehicle or like a house, when you transfer it, if it's a couch, you can give it to somebody, but a property can only be sold or transferred if there are certain documents in place. So you cannot deal with the immovable property in terms of selling it until the executor has been appointed. Even if the beneficiaries intend to sell the fixed property, or if the will expressly compels the executor to dispose of it, the executor only has the authority to enter into a legally binding agreement of sale once a letter of executorship has been issued. I refer you to that explanation earlier on that you distinguish between a nominated executor and an appointed executor. Okay. We often get it where somebody passed on, the children get involved. They instruct an estate agent to sell the property. They someone go and sign a sole mandate, and they get an offer and they sign the sale agreement. The sole mandate, the sale agreements, all absolutely null and void because they simply don't have the authority to sign. That's why it's so important that for all practical reasons, the property should be safeguarded, especially if unoccupied. Okay. You can, if you want to, if the executor hasn't been appointed yet, appointed yet, you can approach a property agent to give you a preliminary evaluation of the property. It's not going to make any difference, but when you sell the property, when the executor sells the property, you must always remember there are that it's always subject to three conditions: that the executive being successfully appointed by the master of the High Court can't sell a property without the executor. He needs to physically sign the agreement. The sale in a deceased estate being subject to the approval stroke endorsement by the master of the High Court, and the sale being subject to the written consent by all relevant beneficiaries. Okay, so if the three siblings, in terms of the will, is going to inherit the property, but it's decided to sell the property, then all three siblings need to agree to the sale of the property in any event. So the long and the short with immovable properties, you can't really do you can't sell it until the executor is appointed. Okay. And simply because nobody's got the authority to sign the sale agreement. If the property is bonded, the bank will expect that monthly repayments are maintained or the outstanding balance settled. So that's something that you need to discuss with the heirs, because the banks won't do it quickly. They won't attach the property and sell it on an auction if they know somebody has passed on. They've been in the game. If somebody passes on in the banks, then the banks move everything to the deceased estate department, and they take a few months before they're really going to insist that the bond gets settled. However, if the monthly repayments are not maintained, then it means that there might be a huge, what's the right word? I can't think of it now. Debt by the time you settle it. So if there are any of the family members that's prepared to maintain and pay the bond, then please do so, and then just put in a claim against the estate to pay. Question to consider: who's going to pay for the monthly maintenance and upkeep of a property in the deceased name? The short answer is that the deceased estate is ultimately responsible, but who pays in practice depends on the stage of the estate administration and the available funds. I mean, if the estate hasn't been reported and the executor has not been appointed, then you don't have money. I mean, you can't pay for the outstanding bond. You don't have available funds. So it all depends where you are. And even if the executor has been appointed, but there's no cash in the estate, then the estate can't pay for the monthly installments, etc. Very important is that death does not stop the financial obligations attached to a property. The cost of owning the property continue until it's transferred to an heir or sold, and those costs are generally payable by the deceased estate. Please note, immovable property forming part of a deceased estate may be sold directly. Now, this has got nothing to do with from death until the executor is appointed, but I think it's important that you understand it, and that can all help with your discussions with the heirs before the executor is appointed. I'm going to read again. Immovable property forming part of deceased estate may be sold directly from the estate and transferred to the purchaser. It is thus not necessary for the property to be first transferred into the names of the heirs before it can be sold. We often people misunderstood this part, and I think they have to first get it into the beneficiary's name, and only then can they sell it. No, you don't have to. You can sell it out of the estate, and then the proceeds will be paid to the bank account of the deceased estate, and the beneficiaries will get their money when the estate is divided amongst the heirs. All right. Yeah, so that's immovable property. There's not much you can do in terms of immovable property until the executor has been appointed. But please make sure that everything is secure, especially if it's unoccupied. Vehicles. That's probably the most important thing when it comes to vehicles, is that you must make sure that it's insured. Vehicles need to be insured to mitigate risk until transfer can be effected. If possible, not always practical, if possible, keep the vehicle in a secure location and avoid using it. However, there are cases where it is necessary to use the vehicle. You can do so, but make sure that ensure that the adequate insurance is in place before doing so. Because if you're not the heir of the vehicle and you use it and you're involved in a car accident, you will be liable towards the estate, so that you can, so that we can make sure that the heir gets what he's supposed to get. Okay. So be very careful. If there's a vehicle, make sure that it's insured. If it's the intention of the of a beneficiary to sell a vehicle directly from the estate, then such sale can be facilitated only once the executor is being appointed. Expired licenses, when the executor is appointed, and until the transfer is effected, the executor can provide a letter to the beneficiaries to renew their license. Then the beneficiary can go and renew the license. Okay. Very important, if a vehicle repayments are not maintained, the financial institution may repossess the vehicle and sell it on an auction, and holding the estate liable for any deficit. Now, from experience, we know that financial institutions are a lot quicker in terms of taking the car back and sell it in an auction than financial institutions with fixed property. So if somebody can see to it that the monthly payments are paid, then please do so, just to make sure that the financial institution don't repossess the vehicle. Then, ladies and gentlemen, we come to firearms. Firearms carry a huge risk for the appointed executor in his personal capacity. I mean, if a firearm is stolen, as you know, and you're the owner of the firearm, and let's say you don't have a license, or your safekeeping was not up to standard, and they use that firearm in a robbery or a murder, you could be in real trouble. And that responsibility basically goes over to the executor when he's appointed. If a will dictates what should happen to a specific firearm, bear in mind that the specific beneficiary still has to obtain a competency certificate for that respective firearm bequeathed to him or her. So you can't just give the firearm to the person that's going to inherit the property, the firearm. He still needs to go for these competency certificate before he can physically take possession of the firearm. So some of the practical aspects of dealing with firearms in an estate should be to ensure that the firearms are held in safekeeping. The safer option would be to instruct a registered firearm dealer to collect the firearms and dealer stock and store them until such time that the transfer can be effected into the respective person's names. Please note that it's important to note that there will be storage fees payable. I looked earlier today, the last payment we did, we paid 3,000 Rand as a once-off and then 300 Rand per month to keep the firearms with a dealer stock store. It might sound like a lot of money, but it's without a doubt a lot safer option. So be careful if there are firearms in a deceased estate. All right, let's have a look at movables. That's now typically, let's say, furniture. Three questions that I put there. I say, we have to empty the retirement unit that my parents occupied. Can I start selling these items? The deceased bequeathed itemized movables in his will. Can I start distributing these items to the specific people? And then family members are coming into the deceased home and removing the movables. What should I do? That first question, remember, the right answer is not to distribute it to the heirs, but sometimes you need to be practical. Let's take an example. It's in a retirement unit. The surviving spouse passed on. I mean, it would be then silly to keep the furniture in that house and pay the levies, etc., while the estate is wound up. Then rather remove everything. If you can, put it in safekeeping, and at least the body corporate can then sell the unit again. So sometimes you need to be very practical about these things. The deceased bequeathed itemized movables. Can I start distributing these items? Again, it depends. Have you got the last signed will? Is that the correct will that you have? Is the estate not insolvent? You need to take those things into account. But as I say, sometimes you have to be practical. And if you do allow that, if you're the nominated executor, make sure that you keep record of who is taking what. Family members are coming into the deceased home and removing movables. What should I do? If you can't stop them, then just make sure that you make a note of who's taking what. I've advised people before. I said, take your camera and a video camera and go make a video of everything that's in the house and make sure that nobody's got access to that house if you're concerned that people will take some of the stuff for themselves. Yeah, it's important to note that an itemized inventory in terms of the will needs or requires an itemized valuation. To appoint the valuator or appraiser to provide an appraisal means that additional cost would be incurred in the estate. It's not always necessary to get a valuator to evaluate second-hand furniture. It depends on the estate and the value of the furniture. It's also important, we're still busy with movables, important that when items are removed, a written acknowledgement of receipt by the person receiving such item is to be provided to the executor. If the executor permits a beneficiary to dispose or even sell these items, it is important that the funds are payable to the estate bank account. Just to explain that quickly, once you appointed as the executor, one of the very first things that you have to do is to open an estate bank account. So if the furniture is sold or anything is sold, the proceeds has to be or have to be paid into the estate account, because the master of the High Court will want to see what we received and if we actually received it physically. The fourth point, important to note that in the event of a minor child being a beneficiary, a minor child is a child younger than 18, it is a requirement to obtain a sworn appraisal for both movable and immovable assets. Such an instruction can only be given once the executor has been appointed to in his official capacity. Also important to think about it that if you drop a will, do you really want your young children to get some of the movables? It could just cause extra efforts, etc. Therefore, no items are to be removed unless practically impossible and a risk to keep them on the deceased premises. Let's have a look at the next one. What about at what stage can a rental agreement be entered into? Now, remember, if you look at the bottom of this page, it says until the executor is appointed, no lease agreement can be entered into simply because the nominated executor has got no authority to sign any sort of lease agreement. So if it so happens that you have to put somebody in a property for security reasons, or whatever the case might be, and if you do sign a lease agreement as the nominated executor, so remember you're not the appointed executor yet, just remember that that rental agreement means zero, nothing. You can't hold the tenant to any of the conditions in that agreement because you simply did not have the authority to sign that rental agreement. Another thing, if you do put a tenant in there and he doesn't pay his rent, you can't sue the person for the rental. You can't take him to court to try and get an order to throw him out because you simply do not have the jurisdiction. You do not have the authority to do something. So if it so happens that you do put a tenant in a property and you're not the appointed executor yet, it's a massive risk. Okay. So let's go through the points. The appointed executor is the only person who has the authority to enter into a rental agreement. Usually, the executor would steer away from such an agreement unless it's absolutely necessary and within the best interest of the estate and the beneficiaries. It's also not advisable to enter into a long-term lease agreement, and the executor may choose for several reasons to enter into a shorter lease agreement. I know it's got nothing to do from death until the executor is appointed, but these things are important for you to know so that you know what you can and what you can't do. Some reasons to enter into such an agreement would be to safeguard the property or to obtain a bit of liquidity in the estate to maintain monthly utilities. Risk involved with the action should be understood. I've explained it to you. If you do enter into some sort of rental agreement, the risk is massive, and you won't be able to do anything because when you sign it, at the time when you sign it, you did not have the authority to enter into an agreement. Funeral policies. Funeral policies are usually held with a funeral undertaker or insurance company, or form part of a final expenses benefit on a life policy. Important second point, the proceeds of a funeral policy do not form part of the deceased estate. Okay. So it doesn't have to be paid into the deceased estate. So it can be done even before the executor has been appointed. That's the funeral policies are paid directly by the insurer to the nominated beneficiary, or in some cases to the person responsible for arranging the funeral. This means the funds are available long before an executor is appointed, making the funeral policy an important source of immediate financial assistance for the family. Only the death certificate is required. Sometimes a letter of executive is required. I'll read it. The letter of executorship is usually only required to claim the funeral policy in the instances where there may be a funeral benefit linked to a bank account. For example, when a savings account was opened and the funeral cover was an added benefit. then the insurance, the financial institution will insist on a letter of executorship. If the funeral policy is linked to a specific bank account, the policy proceeds will be paid only into that account. If the account is with another bank, the proceeds will be paid into the ceased account. The claim can be processed independently of the estate administration process. So that's something separate. So you can start dealing with it the moment somebody has passed on. Life policies is the same thing as funeral policies in terms of it doesn't form part of the estate. No, it doesn't form part of the administration of the estate. The value of the policy does form part of the estate, but that's a subject for another day or a discussion for another day. Life policies usually take longer period to pay out compared to funeral policies, okay? As insurance companies need to follow certain internal protocols at claim stage. I believe it takes anything from 4 to 6 weeks before life policy is paid out after the death certificate is issued, but don't quote me on that. Claims form part, claim forms need to be completed and the death certificate need to be provided. Insurance companies' requirements may differ. The nominated beneficiary, as the nominated beneficiary, you should contact the insurance company directly. Don't wait for the executor to be appointed. You, as the nominated beneficiary, can go directly to the insurance company and they will, if you're the beneficiary and you comply with all the rules and regulations, they will pay the money directly to you. Only on successful admission of the claim will the insurance policy pay out the proceeds to the nominated beneficiaries. The claim can be processed independently of the estate administration process, and usually the financial advisor can assist you with this process. Okay, maybe a tip: regular reviewing of the beneficiaries is crucial. Right, the next one, short-term insurance over assets, a risk before transfer. That's more where there's a fixed property like a house or a car. Before a fixed property or a vehicle can be transferred into the nominated beneficiary's name, it remains a risk in the estate. And this is very important. The estate bank account cannot facilitate debit orders. So it's important to make sure that the property or the vehicle is insured and even after the executor has been appointed. Okay. No funds are available until the deceased bank accounts are closed, and if there are obviously money in the bank account will be paid into the estate, and only then can the executor really assist in paying that. It is advisable that the beneficiary arranges for immediate insurance cover over these assets. Okay. Right. Credit life policies and debt incurred with a financial institution until the claim is settled, either from estate funds or by proceeds of a credit life insurance, it remains a claim against the estate and will continue to accrue interest until settled. So that's why it's so important that if somebody's passed on, that you do what you're supposed to do to get a letter of executorship, to get the executor appointed, because that interest can just accumulate and accumulate until it's settled. Okay. I'll make this statement. Credit life insurance is very costly and the clients don't always opt to take this out. In most instances, a death certificate is required when there's credit life insurance. However, a personal medical attendant report as well as a letter executorship may be required. But that's stuff that we need to, the executors, we communicate with these institutions and make sure that that the credit life insurance is paid out. In an instance with a mortgage bond over fixed property, it's advisable to maintain monthly payments to the bond account if you can afford it as a beneficiary. Any credit on a bond account will be reimbursed to the estate. Short-term insurance over assets, a risk before transfer. I think I've gone the other way around now. Here's a very important thing. People, if there are anybody in the group that's listening to me now if you have got a business and you haven't got a plan in place, I think it's so important that you come and speak to me. I make this statement again. Planning is bringing the future into the present so that you can do something about it now. Ask yourself a question. If you had to die today, what's going to happen to your business? All right. So we took in a estate, I think it was the end of last year. The deceased was the only director, the only shareholder, and he was the only one that could transfer funds and make payments. His wife is still working in the business. She most probably knew more than him, and some of his children, or he had managers, they knew exactly how to run the business. But when he passed on, there was nobody that had the authority to make payments. They nearly lost a very, very lucrative business because of that. I was the nominated executor. We had to rush to get myself appointed, and we had to really press the bank or I became the executor of the estate or the company, and had to press the bank to allow me to have access to the account and make payments, etc. So, Mr. and Mrs. out there, if you've got a business, you need to have a plan in place. If you think about it, let's use myself as an example. I'm an attorney. My wife cannot inherit my business because she's not an attorney. I have to make other plans. You could be an engineer and your wife, or the other way around, your husband doesn't know anything about your business. What's going to happen to your business? Especially if the business is where you get your income for the family. If that business has to just die and not carry on, it will be such a pity. Ways you can do that is to make sure that you've got shareholders, have a shareholder agreement in place, a buy and sell agreement in place, or practically, if practicality is to bequeath the business to a family member, but to somebody that knows how to do it. You need to have things in place that, let's say you've got a partner, to make sure that your partner's wife or the partner's husband doesn't become your new partner. That's all estate planning. Okay. Again, it might not have to do a lot with from death until the executor is appointed, but these things make life so much easier. And as I mentioned earlier on, it's an act of kindness if you are well prepared before death. All right. Shares, and that's the last slide. Also not very relevant, but it's good to know. Shares held in a deceased name can either be transferred or redeemed. Shares can only be dealt with on receipt of a letter of executorship. So before the executorship has been appointed, you can't do anything with shares. The paragraph at the bottom, when a person dies, the executor must decide how each investment in the estate will be dealt with. In many cases, the investment can either be transferred to the beneficiary or redeemed, in other words, sold or withdrawn, and the proceeds paid to the beneficiaries. The correct option depends on the type of investment, the deceased will, the wishes of the beneficiary where appropriate, the rules of the investment institution, and the liquidity requirements of the estate. And as they say in Afrikaans, fluit, my story is uit. If there are any questions, maybe Jean, if you can help me, all the questions in the chat box, have that been answered? Is there anything that I can assist with in terms of questions? If you feel that you want to ask a question, just unmute yourself and then ask the question. I see Runel has put a hand up. Runel, how can I help you?
Good afternoon, Jan. I would just like to find out if you are married in community of property, how would it work?
How would what work, Runel?
Community
The
of
wind up
property.
of the estate.
Community of property, COP.
Yeah, I understand, but you say, how will it work? How will what work? The winding up of the estate?
Own a property together, how would it work then? If one of
All
us
right.
passes.
Okay. So when you married in community of property, by law, you're entitled to one half share of what you and in Europe, you now, what you or your spouse have together. Okay. But when we wind up an estate that where the couple are married in community of property, we have to wind up both the deceased and the surviving spouse's estate. Okay, because it's in community of property. And once you marry, when you married in community of property, the law see you as one, your estate as one. So we have to wind up the whole estate. If in your case, let's say your spouse in his will says that the property must go to Joe Soap, he can only in his will indicate what should happen to his one half share in the property. You will still be the owner of the one half share, and then his half share will be transferred to whoever he nominated in the will. Have I answered your question? I hope I understood your question correctly.
Yes, that is correct, Jan. And then if any vehicles is not on my name, how would that work?
Again, remember, whatever you have, whatever your husband has,
Oh,
it's
okay.
you are half owner. The
Oh,
document that the sorry, you're trying to say something?
no, no, it's all good.
Okay.
All good.
Okay. So although the registration document indicates that the property or the house or the car, rather, you're talking about a car, is in his name, you are entitled to half share of that. So if that car is sold, you are entitled to half of that. It depends on the will. If he says in his will that you inherit everything, then you will get it as well.
Thank you
Okay.
so
Are
much.
there any other questions, John? Are there questions that needs to be addressed?
Hi, Jan. All the questions have been answered so far. I don't see anything else in the chat box.
Okay. Awesome. If there are no
Jan,
other questions.
there is a question from Peter. The question is, does the executor have to provide feedback to the master?
So the only time you report to the master is one, obviously when you apply to be appointed as the executor. Then two, when you submit your L&D account to the master and the master will approve it. Then it has to lay in for inspection at the local magistrates court. And then you have to, if you transfer a property, you have to get we refer to as the consent of the master. It's not really a consent. He just confirmed that there are no objections, but we talk about the masters get the consent to the sale of the property. But you don't have to physically report to the master and say, Master, we've opened a bank account, or Master, we've now closed the deceased account. That you report to your heirs. So we report on a regular basis to the master, to the heirs. However, although they don't do it anymore, but years ago when things still ran smoothly, the master would, after 6 months, send a letter to the executor and say, Mr. or Mrs. Executor, you've now been appointed as the executor for 6 months. We haven't received your the L&D account. What's going on? Give me an explanation why the executor, why the L&D has not been approved. And then you have to report to the master. But nowadays, I can't even remember when last such a letter was issued. I hope that answers the question. Anybody else? Sean?
Yes, Jan,
Questions?
there's another question that has come up from Anna. It is when it is an 18-3 estate, do you still advertise the death?
So let me explain what an 18.3 is so that everybody that's still here understand what it is. If an estate is in value less than 250,000, we refer to it as an 18.3 estate. John, you guys just mute yourself. If it's less than 250,000, the value of the estate, we refer to it as an 18.3 estate. Then a letter of authority is issued and not a letter of executorship, although we talk about a letter of executorship. And then once the letter of authority is issued, then you are done in terms of winding up the estate. You take that 18.3, that letter of authority, and you can close bank accounts. You can transfer the car into somebody's name. So no, you don't have to advertise in the local newspaper or the government gazette if it's an 18.3 estate. Are there more questions?
Jan, there is a question. I just want to make sure that I'm finding the right one. That's already been answered. So from Louise, what happens when the executor passed away before the estate trust account was closed and the tax DEC request was sorry about that. Before the estate trust account was closed and the tax DEC requested and deregistered.
Okay, so if an executor passes on, then everything comes to an hold and the master needs to appoint a new executor. If the will makes provision for an alternative executor, then he must be appointed. If there's no provision to that for such a situation, then the family will get together. They will nominate an executor. The master will appoint that executor, and that executor will then take over and finalize the estate.
Okay,
Right.
thank you, Jan. There's one more question, and then we have to call it time. The question is from Graham. What happens if a beneficiary in the will that's not a direct family member has passed on by the time the will holder passes away?
Okay, so it depends again on the will. Normally, what we would say is if a will is drawn up properly, you would say that Joe Soap must inherit X. But if Joe Soap predeceased me, then it must go to ABC. Or you could say, just use it, we use the words per stirpes, then it means it will go down to his children. It depends on the wording of a will and circumstances. Sometimes that will be divided between the other heirs, or it could even be that that specific inheritance will be divided in terms of the Interstate Succession Act. And that act described what should happen to assets if, for instance, there's no will. Then this Interstate Succession Act will kick in. So it all depends on circumstances.
Jan, as a final question, there's a question that came in from Peter saying, if there is a dispute amongst heirs, is it resolved by the executor?
Sure, Peter. We spend so much time in sorting out issues amongst heirs. It's unbelievable. The moment there's money involved, the rules change and children fight. It's unbelievable. Anyway, yes. So it is our responsibility to make sure that things get sorted. But my advice is, again, it's planning. I say to people, when I see them for a will, they say, my three children must inherit in equal shares. I say to them, if there's any indication that there's friction between the siblings, then please rather specify who should get what. Because it's just unbelievable how children can fight. It breaks families up. So I normally advise clients to specify it. And from my experience, I've got three children. What I've done is I've specified basically everything. Even my mountain bike, I specified who should get it and who shouldn't. I know who should get it. But Peter, to answer your question more directly, the executors can only do so much, but we try our utmost best to sort out issues between siblings.
Jan, that's all the questions, and I think we have run out of time.
Okay, so in a closing statement, people, if you haven't got a will or if you want to amend it, you've got the will's email address, email us. We will set up an appointment. If you need estate planning, contact me. So we sit around the table. That's not something that needs to be or can be discussed via emails. We have to look each other in the face, in the eyes, and plan. And there's so many things that needs to be taken into account. Thank you for attending. I thoroughly enjoyed it. I hope you enjoyed it. We will have another seminar in September where the topic will be wills, what can go wrong. You'll be surprised what can go wrong, but we'll keep the database and we'll invite you guys as well for that webinar in September. Thank you, everybody. Have a good afternoon.